or good morning to everyone, wherever you're joining from. Our session is live now. I would like to welcome all our panelists and attendees to the second roundtable discussion organized by Sultan Abdullah and Partners in this year's Paris Arbitration Week. The topic of our discussion today is advocacy in international arbitration, tips and pitfalls. And just by way of introduction, I am Ahmed Durrani. I'm a senior associate at Sultan Abdullah and Partners, and I'll be moderating this session. With us today, we have an esteemed panel of speakers. We've got Mr. Alec Emerson, Mr. Paul Key QC, and Mr. Anirudh Krishnan. Before we begin, I'll just briefly introduce our speakers. Mr. Emerson is an independent arbitrator, and he's got extensive experience of commercial and construction arbitration in various jurisdictions around the world, including England, mainland Europe, Asia, and for our purposes, I think the Middle East. He's currently based in Dubai, Mr. Emerson, but he takes appointments, like I said, worldwide. Before setting up his independent arbitrator practice, Mr. Emerson spent around 4 decades with Clyde & Co. in various capacities, including as the managing partner in their Hong Kong office. And he played a pivotal role in around 2 decades of his time with Clyde & Co. Dubai in setting up their MENA practice. We are very grateful to Mr. Emerson for joining us today. Our second speaker is Paul Key QC. He's a silk at Essex Court Chambers. He's ranked as one of the leading commercial silks in England. His experience and expertise ranges over a broad array of commercial litigation and arbitration matters, including, very importantly, investment treaty arbitrations, and he's considered to be one of the few silks who have extensive experience in that field. He also does a lot of maritime and admiralty disputes. Mr. Key has appeared as an advocate in over 300 arbitrations worldwide, and I'm certain that number continues to rise every day. He appears regularly before the English courts at all levels, as well as foreign courts in matters relating to arbitration proceedings. And we are grateful to Mr. Key as well for joining us today. Last but not least is Anirudh Krishnan. Mr. Krishnan is the founding partner of AK Law Chambers, which is based out of Chennai and Bangalore in India. Mr. Krishnan routinely appears before the various high courts in India, as well as the Supreme Court. He is considered to be one of the leading young commercial lawyers in India, and his experience ranges over a wide spectrum of commercial disputes, including construction, and he's considered to be one of the leading lawyers in the construction industry as well. Mr. Krishnan has extensive experience of arbitrations both within India and outside, including arbitrations seated in Singapore, London, and the Middle East. And we thank Mr. Krishnan for joining us today. Before we proceed with our discussion, I would just like to explain the format to our audience. It's a roundtable discussion. I'll be asking questions relating to advocacy in international arbitration to our panelists. We expect our question and answer session to last for around 45 minutes. Thereafter, we have dedicated a 10 to 15 minutes spot for questions from the audience. And I would request the audience members to type in their questions in the Q&A tab on the bottom of their screens during the course, if they wish to do so during the course of the session. Questions can also be submitted anonymously. So if some of the audience members are shy, they can always hide behind the anonymity. As far as my questions to the panelists are concerned, they will be directed at specific panelists, but obviously the panelists are free to jump in if they want to contribute to any of the questions that I'm asking. So with that, we can move to our first question, and I would like to start with Mr. Key. Beyond what we consider the obvious motive of advocacy in arbitration, which is to convince the tribunal of a party's case, what would you say is the purpose of advocacy, and or what is it that counsel should try to achieve from their written and oral advocacy?
Well, thank you. It's a great pleasure to be joining this. There are a couple of things which are often lost in the idea of the purpose of advocacy. One is that in convincing or persuading the tribunal, it is sometimes tactically advantageous to put forward points which do not persuade the tribunal. Often, as a matter of psychology, tribunals or courts, or judges like to split or apportion the result on various on issues across a case, and so that if one can find 1, 2, or 3 issues where in fact you are losing, it may help in winning the overall critical matters which you need to win. So that's one point. The second point is that sometimes we forget that the tribunal is not the only, sometimes not even the most important audience in the room. We as advocates usually have a very important client who's closely following a case, and ultimately the case is their case. It is their arguments that need to be put forward, and if it is professionally proper to put forward a case or an argument, even though one knows it is very likely to lose, it is the client's right to have that argument put forward. And well, in some sense, if one puts it in terms of persuasion, one's trying to persuade the client that you are a good advocate acting to put forward all the case and all elements of the case that they wish to put forward. And sometimes, even when it gets down to, there's a third element, even when it gets down to the level of more junior advocates, sometimes amongst the audience of the tribunal, your client, there is also the audience of your more senior members of your legal team to show that how well prepared you are and a good advocate you are. And you're trying to persuade them that you have taken on board the lessons they have given you. So, of course, the tribunal is critically important, but they're not the only target for the source of opprobrium or persuasion, depending upon how one views it from the client or from other members of the legal team.
Thank you very much, Mr. Key. You raised some interesting points, and I'll return to them at the end in the question answer session if time permits, especially about the distinction that you drew about if it's professionally proper to put forward a case, even though you might think it's a losing argument. And we'll discuss, if time permits, what professionally proper would entail from counsel's perspective. My next question is for all the panelists, and we will start with Mr. Emerson, and then we'll move on to Mr. Krishnan and then Mr. Key. This is a sort of general overarching question before we go into the specifics of or specific aspects of advocacy in international arbitration. So, Mr. Emerson, can you please, for the benefit of our audience, explain some of the core principles that of written and oral advocacy that counsel should keep in mind or implement in their practice?
Yes, of course. It's quite interesting, I think, particularly the last one I'm going to mention in the context of what Paul had to say. I think it would probably be agreed that core principles of both written and oral advocacy that counsel should implement are to present the client's case clearly, persuasively, and most importantly, I think, ethically. And that raises the question of what ethically means. And I think that wherever, pretty much wherever in the world the advocate or counsel comes from, ethically means not knowingly presenting false evidence or contentions, not making untruthful submissions, and acting with honesty and integrity. And that's recognized, for instance, in the IBA's general principles. It's reflected in the LCIA's annex to its rules. And I think generally, advocates should avoid guerrilla tactics. I think it's a matter of ethics, abusive conduct, or overly aggressive tactics. Now, in terms of honesty and integrity, there's recently been a further chapter which illustrates the perils that an advocate or lawyer can face if he doesn't act with honesty and integrity. And that's the recent Court of Appeal decision in relation to Peter Gray, a former partner of Gibson Dunn, who was found to have allowed evidence that he knew to be false to be submitted, in this case, to a court, but the same principles would apply, I would submit, in relation to arbitral tribunals. I would also like to make a second point in terms of core principles. Is it a principle or not? You might want to argue about that later. But I think that when I was in my first training seat in relation to dispute resolution, I was told that the golden rule of advocacy was do not annoy the judge or the tribunal if you can possibly avoid it. So in practice, what does this mean? I mean, my view is that advocacy applies to how you manage the whole conduct of an arbitration, written pleadings and submissions, as well as oral advocacy. In practice, tribunals don't want to see constant squabbling emails between parties. They want cooperation on procedural matters and to see only short, reasoned applications and replies on matters that can't be agreed. Tribunals don't like, generally, to receive repeated requests for time extensions, except in exceptional circumstances. And these should be capable of being dealt with, frankly, between parties, most of the time, before the expiry of the time limit, rather than having whinging afterwards, if I can put it that way. Tribunals also soon identify a party who objects to everything that the opposing side have to say in principle and will not cooperate, and it doesn't promote that party's case. So those are a couple of areas. The first, definitely a core principle. The other, I think, various aspects of what I was always taught was the golden rule, and I hope that leaves some space for my colleagues to also comment.
Thank you very much, Mr. Emerson. The golden rule is certainly very interesting, and I would like Mr. Kishan to build upon that. Apart from the core principles that he wishes to discuss, if you can also discuss the point raised by Mr. Emerson regarding, putting forward your case in an honest, concise, and convincing manner. If you can touch upon the importance of that from an advocate's perspective.
Yes, thank you, Ahmed, and thank you very much for inviting me to be part of this panel. To start off where Mr. Emerson left off, I think one of the key issues of advocacy and the key principles to keep in mind when putting forward your case effectively and efficiently is to focus on the arbitral tribunal. Try and understand the background of the tribunal. You may have a tribunal with a civil law background. You may have a tribunal with a common law background. Therefore, if you are arguing an issue relating to common law before a tribunal with a civil law background, you perhaps spend a little more time focusing on key conceptual issues. You also would want to assess how the tribunal looks at a case. Some tribunals would go strictly by the letter of the contract. Others would prefer going by business common sense. Some tribunals may look at where equity lies and work backwards to see what contractual scheme fits and how ultimately justice can be done. So once you understand how your tribunal behaves, well, you might have appeared before a few of them in the past, so that would certainly help. But otherwise, it's good to do your due diligence and assess the tribunal through the course of the arbitration. Then you know how to package your arguments so as to appeal to the tribunal. So I think the first core principle is know your tribunal and focus on the tribunal. The second is to structure your presentation, whether it is part of your oral advocacy or written advocacy. No tribunal likes a counsel to just ramble on. So you split your presentation into various topics and subtopics and ensure that you keep the tribunal engaged. And the third principle that I would like to put forward that leads from the second is the use of a PowerPoint presentation or tables and charts to keep the tribunal engaged. I think this is even more relevant in the age of virtual hearings, where a tribunal does not, has to spend hours looking at a screen. So if you are able to sort of come up with an effective PowerPoint presentation and put in all your key points in there, that helps keeping the tribunal engaged. So these are three core principles I would like to put forward. There are, of course, many more, but I think I will leave it at that for now.
Thank you very much, Mr. Kishan. Certainly you make some helpful points there. Mr. Key, just one common theme I think which emerged from both Mr. Emerson's and Mr. Kishan's discussion was the importance of knowing the tribunal and catering to the tribunal. So if you would also like to give your perspective on it, along with any other principles that you would like to discuss.
Yes, if I start with my principles, and I of course agree with the comments which have been given to date, I would summarize it as being clarity, simplicity, logic. Clarity, it needs to be obvious, clear to the tribunal what in fact you are arguing. It might require some explanation or some points and subpoints, but it should be at some stage obvious to the tribunal what in fact you are arguing, what your position is. So clarity. Simplicity. What one needs is an argument which enables a tribunal, who is often faced with a mountain, a tsunami of material, well beyond what they could reasonably be expected ever to read, still less to understand. One needs to present the case in a way which makes quite a complex and often detailed history and background to issues simple. Not overly simple, but simple enough that you present the core of your arguments. So clarity, simplicity. Third one is logic. There must be some logic to your analysis, which can be understood by the tribunal and will be regarded as persuasive to them. One keeps in mind the fact that there should be some logical structure to the argument that will solve a number of problems. So clarity, simplicity, logic. Now, in relation to the question about knowing the tribunal or assessing the tribunal and what one does in relation to one's assessment, it is certainly true that one must take account of the background, both background experience and background legal system of the tribunal or the tribunal members. Obviously, one can determine that in part by just simple knowledge of their CV and their history. Sometimes one will have direct experience of the person, and different styles work with different arbitrators. And it is obviously foolish to adopt a style which is not the style appropriate for the arbitrator. Some arbitrators want long, detailed cross-examination. Some find it extremely unhelpful to have long, detailed cross-examination. I mean, as a broad, very, very broad generalization, there are some from the civil law background who do not really understand why we need to have long hearings, including long cross-examinations. They sometimes regard things as sort of able, really, including the final hearing, to be largely dealt with on the papers. You read the materials, you see the written submissions, and you can make a view, or take a view. Whereas common law lawyers, at a very high level of abstract generalization, are more comfortable with the idea of a long oral hearing. But again, these are just generalizations, and everything depends upon the specifics of the individuals that form the tribunal.
Thank you, Mr. Key. And I think that feeds very well into my next question, which is directed at Mr. Emerson. And this is an issue that both Mr. Key and Mr. Kishan touched upon, which is the difference in the backgrounds of counsel and arbitrators involved in arbitration. And given your experience, especially in this region of common law and civil law lawyers, do you see that there's a difference in their approach, as Mr. Key has indicated? And if there is a difference from the tribunal's perspective, what can be done to resolve those differences and give certainty as to procedure to the parties?
Right, I'm going to diverge a bit from Mr. Key's views, because to be honest, I do believe, and my experience is that these days, experienced and good counsel, wherever they're from, and whether they're from a common law or a civil law background, will generally approach a case in a similar fashion, i.e. whatever the proper law and the procedural laws of the case is or are, most experienced counsel know how to plead it in writing and how to deal with the oral aspects of the case, including cross-examination. Historically, it's certainly true that civil law background lawyers will have had less experience of cross-examination. But I think international arbitration has become a specialism in its own right, and that therefore there's been a convergence of approach. I do agree, though, that tribunals can assist any potential differences. And I think that's particularly the case where on one side you have experienced and knowledgeable counsel, and on the other side you have people who are less so. But I think even where there's equality of arms and counsel from the same backgrounds, one of the things that can assist to try and have things track in the right way is to have a very detailed first procedural order. And unfortunately that means, and I think a lot of people subscribe to this view, that means that procedural orders, number one, do tend to get longer and longer, except in a few areas, and particularly London Maritime Arbitration Association terms arbitrations. And I think that doesn't happen in those cases because usually the lawyers involved and the arbitrators involved come from a relatively well-defined and fairly small pool, and all know what they're doing, and the terms provide a very good framework. But in other arbitrations, I think it's worth putting in the extra time and effort to have a detailed first procedural order, so that the difficulty then becomes, where you have that inequality of arms, the difficulty becomes to get the less experienced team to actually read, understand, and comply with Procedural Order 1. That appears to be a problem sometimes, even when the tribunal goes to great lengths to indicate that it does expect that order to be read and complied with. And then when things progress in a way that they're not at all in accordance with what has been directed, which unfortunately does happen. So those are my views on the common law, civil law non-divide, as I see it, or not great divide, and on a bigger problem of inequality of arms.
Thank you, Mr. Emerson. Certainly your views are quite interesting, at least for me, given your experience of being an arbitrator in this region. One thing that you mentioned was that experienced counsel, irrespective of the background, would know how to plead their cases. And my next question is linked to that comment, and it's for Mr. Kishan and Mr. Key. So I'll start with Mr. Kishan first. When it comes to pleadings, in practice, we see that there is a preference between counsel for adopting a memorial style approach or a traditional common law pleading approach. And both are right in their own way. But from your personal experience, which one would you prefer, and which one would you consider would make for better and more effective advocacy?
I think it really depends on the nature of the case. I think for instance, a complicated construction dispute, I would prefer the common law style of pleading, since issues and disputes are crystallized before the stage of evidence. In the memorial style, there is a front loading of all the documents and all the evidence, and you may end up pleading evidence on aspects that are ultimately not disputed. So I feel, so let me give you an example. Let's look at a variation claim in a construction dispute. You may have one issue relating to interpretation. So in your pleadings, you would include pleadings on interpretation of the contract, and you would then go into some detail on quantification. Now, if you are following the memorial style, you would lead evidence on quantification at the outset along with your memorial, and you would file witness statements to support the quantification along with documents. But it may so happen that the other side, the respondent, may not dispute the quantification in a given case. They may only dispute the interpretation, in which case the entire evidence on the quantification becomes futile. So in a complex construction dispute or any dispute involving complicated evidence, I would prefer the common law style. So issues get crystallized first, and thereafter the evidence process follows. But in a simpler dispute, I think the memorial style is far more effective, as it is a faster process and there is a front loading of evidence which helps.
Thank you, Mr. Kishan. Mr. Key, your views?
Well, I think I broadly agree with those remarks. There are, of course, two fundamental purposes behind memorials or pleadings. One is to identify the issues between the parties, including what issues need to have evidence led on them or produced on them so that you can fill evidential gaps for the tribunal. And secondly, so that you know, or so that ultimately the tribunal knows what issues it needs to decide, because those are defined by the exchange of memorials or pleadings. The second is, which is where memorials often have taken off and sometimes in a bad way, is a sort of de facto means of persuading the tribunal. And memorials, unfortunately, get longer and longer and longer. And again, there's a great swathe of material produced, which unfortunately it's unrealistic to expect tribunals to read in a thorough and digestible manner before the hearing if it's memorials. So although it seems in today's world somewhat old-fashioned, because people tend to like memorials, law firms like memorials, I do see that in some cases, particularly a complex construction case, pleadings can work well and better than memorials. But the critical question is it depends. It depends on the case, the number of issues between the parties, how easy it is to describe those issues, whether in pleadings or memorials, and whether it's understandable or anticipated in advance what the issues are, so that you can actually produce the evidence in a memorial, or do you actually need to crystallize those issues by way of a pleading beforehand? And again, of course, fundamental to all this is the tribunal. What does the tribunal want? What does the tribunal think is going to also be most helpful to it? And there is much, perhaps the most important part of that particular debate in comparison with the parties and the council.
Thank you very much, Mr. Key. My next question is for Mr. Emerson, and we are staying on the topic of written advocacy. So apart from your main statements of case, whether they are memorials or traditional pleadings, another aspect of written advocacy would be written oral submissions and written closing submissions before and after an evidentiary hearing. We would like to understand from you the tribunal's perspective as to what the tribunal expects from these two submissions.
Right, thank you. Well, I'm not entirely sure to what extent every tribunal would have the same view, but I'm quite happy to tell you my views on it. And I do believe there should almost always be written openings. And of course, that assumes there is going to be a hearing. I mean, there are cases which are capable of being dealt with on documents only. And I think that's often overlooked. I think quite often everybody wants to have a hearing, but there are cases where it's simply not necessary. But taking large cases where a hearing is definitely needed, then I think usually a week or two before the main hearing, there should be written openings. Why? Because it's at that point when pleadings are complete, when the written fact evidence is complete, and when the written expert evidence is also complete, or should be, then it's very useful for each party and the tribunal to have a summary or route map of how each party puts its detailed case. And that's what we expect to see, basically pulling the strands of the case together before the hearing. Then, although your question is about the written openings and closings, I did want to make a point about oral openings, because often there will still be oral openings. And it's a complete waste of time, in my view, to rehash the written openings, or even worse, for counsel to do what is not advocacy at all, but just to read the written openings. And believe you me, I've had cases where that has happened, notwithstanding the fact that the tribunal specifically directed that it shouldn't happen. That, of course, doesn't do that party's case any good. Whether it does any harm is another question. But what you don't want to do is to bore the tribunal to death, which I think is a point that Anirudh made perhaps slightly more politely when he was talking about having PowerPoints, things like that. But reading what out loud, verbatim, what the tribunal, you can take it, has already read, is not advocacy. So written closings at the end of the hearing, I'm actually a fan of oral closings where possible, because that tends, if the council have a relatively short time, half a day off or even a day to put the oral closings together, it certainly concentrates the minds and tends to get oral closings that really focus on the key areas. But I won't say more about that because I think Anna may have something to say subsequently. Written closings have certainly become the norm, and in many cases there's a reluctance by parties to do oral closings. So written closings are normal in international arbitration. And what I would like to see in them, and I think most tribunals, is each party's final position on the issues after hearing the oral fact evidence and the oral expert evidence. And in some cases, particularly complex construction cases, the closings have now become a sort of updating of the written openings, confirming or amending those openings. I think that's not a bad way of doing it, but the closing should pull it all together. There's also something I'd like to mention in passing, which is, I don't know to what extent my fellow panelists have heard of the Shearsing schedule, or indeed the audience. But one of the things that goes into every award is the tribunal's summary of the parties' positions, and there is a fellow arbitrator who has adopted something called the Shearsing schedule, which is an opportunity for the parties, in addition to their closings, to have X number of pages, depending on the nature of the case, in which they draft a summary of their cases for inclusion in the award, and which the tribunal can quote verbatim as their summaries, and they of course wish to comment on that. But I think that's quite an interesting idea, and I've used it in one or two cases where I've sat with Niels Shearsing. So there are a few thoughts. I think both written openings and written closings used and drafted properly are extremely helpful.
Thank you very much, Mr. Emerson. Mr. Kishan, following on from what Mr. Emerson has just said, and he touched upon oral opening and oral closing submissions, what would you say would make oral submissions effective? Because as Mr. Emerson mentioned, the things that counsel should not do, including repeating or rehearsing the written opening submissions, what would you say are some of the things that counsel can adopt in their oral submissions to make them more effective?
I'm glad to hear Mr. Emerson's views in support of detailed oral closings, because I completely subscribe to that view, and I find that most people do not. So I'm very happy to see somebody who subscribes to that view. So as Mr. Emerson mentioned, when there are written opening submissions that have been submitted, it is futile to repeat the same thing during your oral opening submission. So when you do submit written opening submissions, there's very little left for your oral opening submissions. What I would do is focus on conceptual issues and purely interpretational issues in my opening submissions, and I would keep it very brief. The closing submissions, on the other hand, in my view, should be far more detailed, since you need to tie in all the evidence and sort of put the final story in place. Right? So how I would demarcate issues of opening and closing would be, if there is no issue of evidence involved, then I would cover it in my opening. Otherwise, I would perhaps just give a very broad overview, considering that written openings would already have been submitted, and I would leave it for a detailed closing. Again, very often, given the because depending on the complexity of the case, you would not have time to cover every single issue. Therefore, you also need to pick as to which are the issues you're going to cover in your oral submissions and which are the issues you would leave purely to your written submissions. For deciding on this issue, I think it's again important to know and assess your tribunal. So, for instance, if you are arguing a dispute on Indian law and all three arbitrators are not familiar with Indian law, but say they are familiar with common law, and Indian law makes a departure on a particular aspect, I would spend significant amount of time pointing out the departure that Indian law makes and explaining that concept. Because ultimately that's going to have a bearing, right? And so therefore I would focus in my in my oral closing on key conceptual issues and how the evidence ties in with the concepts that were already set out in the written opening submissions. And at the end of the day, I would also spend a fair amount of time trying to understand the concerns of the tribunal and addressing them. Through the hearing, you would have got an inclination as to what are the issues about your case that troubles the arbitral tribunal. This could either be through direct questions that come from the tribunal, perhaps during your opening. Sometimes questions that the tribunal may put to a witness, or the reaction of a particular member of the tribunal to a certain line of questioning during cross-examination, etc. So I would focus on those issues, note down during the hearing that these are issues that have actually troubled the tribunal, and then try and address those issues during the closing. Sometimes when questions are put during opening, you would answer it then and there, but you may want to reflect on those and come back with a more detailed explanation at the time of your closing submissions. Yeah, so, and I'm also a big fan of written closing submissions after oral written closing submissions.
Thank you very much, Mr. Kishan. Those views are indeed very helpful. Another important aspect of oral advocacy, and probably one of the most significant aspects rather, would be cross-examination. And this is something that Mr. Key touched upon at the start of the session during when he was explaining the general principles. So my question to you, Mr. Key, is that what are the important principles and tips for advocates around the world to make sure that their cross-examination is effective in arbitration?
Cross-examination brings up four important issues. The first is that the cross-examiner must have a good technical base of the cross-examination. In other words, they must have the skills to be able to do a cross-examination, which is independent of the actual case involved in, but just they know how to present documents to the witness, how to ask leading questions in general, when non-leading questions is appropriate, when to interrupt the witness, when not to interrupt the witness, how to interact. So they need the skills. And that largely arises by virtue of the constant learning process that one goes through every cross-examination one does. And when one's done 300, 500 cross-examinations, one will likely, inevitably be better than someone who's done 3 or 5 cross-examinations. There are also courses that one can take and reflecting on what has worked and not has worked, and what has not worked in cross-examination. So first topic is the skills. One needs the skills. Secondly, one needs to master the materials and the case theory in the particular case. In other words, it is critical to know what you are trying to achieve by way of case theory, what evidence you are trying to get, or what attacks you need to make upon a particular witness. And to do that most effectively, one needs to know the materials in the material before the tribunal as well as possible. You need to know them in broad terms better than the witness does. That's the second point. Know the materials and the case theory. Third point is one always needs to question oneself. Why am I doing this? Why am I asking a question? And this is the great issue for cross-examiners, because cross-examination is a moment of great drama in some senses in a hearing. It is where things are out of control for the counsel and the people and the clients. Things are newly emerging, and no one quite knows what's going to happen moment to moment. So it is a moment of great drama. But sometimes counsel get caught up in this drama, this great play, and get caught up in their own rhetoric and their own importance, and forget that actually maybe this is not helping the tribunal at all. Maybe this is annoying the tribunal. Maybe this is being destructive to one's own case. So one always needs to question before one starts a question, or one starts a line of questioning. One needs to question oneself, am I actually advancing my client's case by asking questions on topics? That's the third issue. Always question, why am I doing this? And the fourth topic is simply, I think simply it's an important topic, but it's a simple point. There are certain professional obligations in relation to cross-examination, depending on which jurisdiction one comes from, and as a matter of good tactics, these things apply across the board. In the common law, particularly in the English system, it's regarded as, described as the rule in Brown and Dunn, which is an old case, but it provides the rules as to when one must cross-examine on certain issues. And the broad idea in the English system, and English lawyers, but it applies to many common law systems as a generality, that one can't accuse a witness in closing submissions of having lied if one did not present them with an opportunity to explain their version of the world, to explain the position. In other words, one must ask the question to the witness, and one can't simply avoid the topic entirely and then in closing submission say that that witness has been lying throughout the course of their witness statements. That would be improper. And I think whether any professional legal system requires that as a matter of strict technicalities, it is just a matter of good practice. Tribunals usually are unimpressed with the idea that you leave for the last moment in closing submissions the argument that a witness was lying in their witness statement when you never explored that with the witness. So those are the four topics. Have the skills down to do cross-examination, know the materials and the case theory. 3, ask yourself, why am I doing this? And number 4, be aware of any professional obligations or constraints which actually require you to ask questions as a matter of professional necessity. That's all.
Thank you, Mr. Key. Mr. Emerson, one point that Mr. Key mentioned was the need or the requirement to put a party's case to the witnesses. And in practice, what we've seen is that arbitral tribunals generally tend to be more lenient than courts would be when it comes to putting a party's case to the witnesses. What is your take on this aspect of cross-examination, the need for putting a party's case to the witnesses?
Well, I think that really only applies in terms of where you're trying to suggest that the witness, as Paul said, is not telling the truth. Because otherwise, in general terms, I'm not sure that I agree that the aim of cross-examination is to put a party's case. The way I see it is actually, in some ways, the opposite. The aim of cross-examination is to destroy the particular witness evidence, if possible, or at least, to put it more moderately, to challenge the witness's evidence or test the evidence or pinpoint weaknesses or identify credibility issues. And that applies to both fact and witness and expert witnesses. But as Paul has said, whether you're cross-examining facts or experts, what is required is very detailed preparation. I'm not going to say much more on that because, as you know, I've had to take a break from a hearing. And I do have to go back in 4 minutes' time. So I'll keep that response brief. And I apologize that I will suddenly have to go. But there's, I think the last time I counted up, there were this is a virtual hearing or a hybrid hearing. There were 30 odd people on the in different parts of the world on the Zoom link. So I apologize for that, and but at least that spared you anything else I might want to say about cross-examination.
Thank you very much, Mr. Emerson. We are very grateful that you've taken out time.
I might, if I could also just say that in terms of practical steps that lawyers can undertake in terms of learning and improving as advocates, I would recommend a bit of reading. Although it's 4 years old, there is a GAR guide to advocacy, which I think is worth a look. But if you can't face more than 300 pages, which is what I think that is, there's a very useful little booklet that the Singapore branch of the Chartered Institute of Arbitrators produced late last year, which is called A View from the Other Side, in which 50 arbitrators provided one tip, and that produces a large number of tips in a very readable format. So I have those suggestions. And as I say again, I do apologise that I will have to disappear in about a minute and a half now. I'm sorry about that.
No worries. So thank you very much, Mr. Emerson, for your time and your insightful comments from the tribunal's perspective. And as Mr. Emerson was discussing the practical steps right at the end, I'll put the same question to the other two panelists. We'll start with Mr. Krishnan and then Mr. Key. Beyond the concepts that we've discussed in this session, what are some key practical steps that lawyers and counsel can undertake to improve their advocacy and their skills?
Well, I think the first thing that an advocate needs to practice is the ability to remain calm and not reflect their take on the happenings of a case. So the other side should not be in a position to just look at the lawyer's case and know that, well, it's not going too well, or they're very happy with what they've got from a witness. So I think the ability to remain calm is one thing that is absolutely crucial. I think the second I think one important tip would be to just observe counsel around you and look for pros and cons in their style of advocacy and try and take the best from what you see. The third aspect that I think, which has personally helped me a lot, is academic writing. When you write articles or books, you sort of break down legal issues and try and simplify it for the reader. Ultimately, when you look at advocacy, whether written or oral, it's exactly that. Therefore, try and write as much as you can, and that sort of helps you improve both your written, directly your written advocacy, and it helps channelize your thought process. Fourthly, I would say internally debate your case thoroughly. So you get contra views. This prepares you for questions that may come from the arbitral tribunal. So this is another aspect that I think is quite important. Thank you.
Mr. Krishnan, Mr. Key, any steps that you would recommend?
So I think focusing on the oral advocacy, it is true, in particular when it comes to things like cross-examination, it is true, as Alika said, that there is a number of helpful books. In my view, those are actually for beginners and intermediate intermediate advocate probably the least effective form of understanding and working out what to do, because they assume a lot of trial and error experience. And it's sort of saying, having done your first 23 cross-examinations, what now can you do to take your experience and your skills to the next level? I think for those who are beginners and intermediates, the following is sometimes helpful. Number one, it's to practice. So whether that involves formalized training, and there are a number of good courses. One is run by FIA, Federation of International Arbitration Advocacy, which goes around the world. It's been at least twice, I think, in India. It goes to Geneva, it goes to London, Singapore, Hong Kong, all over the place. They run very good, long, intensive 1-week courses about oral advocacy. And so courses like that, it doesn't have to be that, or doesn't have to be that long, but courses are very good, where you are videoed, you can see your own mannerisms and see your own foibles, and you get specific tips from people saying, you didn't realize, I think, but every time you ask a question, you say, am I right? Don't say, am I right? So you're given specific individual guidance. That's very helpful. The second thing is actually to do oral advocacy. The more you do oral advocacy, the better you will get. And I think some people assume that somehow they're going to be the world's greatest oral advocate just by reading and doing some training without actually ever going into the hearing room and doing it. Realize that we all start as beginners. At some stage, you've got to get into the hearing room and do your oral advocacy. So that's the second thing. The third thing is to reflect on what has happened and what you have seen and what others have seen. In other words, consider why did things not work, or why did they work? And when you reflect on it, you will get some helpful insights, one hopes. Reflection also includes, to the extent it's possible, reading transcripts, because transcripts of particularly of cross-examinations are often now what parties and tribunals use to remind themselves of what happened. In other words, our memory of the actual moment of cross-examination is a bit dim and distant. What we use when we are persuading a tribunal that something happened in the course of cross-examination is we use the transcript. So read transcripts and see when you see a run of questions and answers, was it successful or unsuccessful? And if it was successful, why was it successful? And use that and repeat it later on. And then once one gets to the stage of sort of intermediate or similar level, then of course one can take on board the advanced tips, which come from books such as Alec was identifying, and there are many and varied books. But often those are not so useful to beginners or beginner intermediate people, because they have a lot of assumed knowledge. They're more down into the detail of really small minutiae tips, which can take you to the really advanced level. So those are some ideas.
Yeah, thank you very much, Mr. Key. Before we conclude, we've got some quick fire questions from the audience. The first one is for Mr. Key.
Yes.
I think it's the case law that you mentioned. I believe it was Brown and Dunn. Okay.
So I haven't. I'll call up the question. Name the book. Okay. So I haven't got the question in front of me. If you, Ahmed, if you could tell me.
Sure. It's from a gentleman called Khalid, and he's asking, what is the case that Mr. Key stated to form the standard of professional obligation?
I see. Yeah. So there are two separate ideas which I was mentioning, and we need to separate them out to identify what we are talking about. The first I mentioned in the very first question, which I was asked and answered, which was about who are you trying to persuade and what's the purpose of advocacy. And I mentioned that one of the things was you need to be advancing your case. to the extent it's professionally permissible or consistent with your professional obligations. And usually that's that general obligation is found in the professional regulations applicable to lawyers wherever someone might be located or registered. So in England, for example, there is a professional obligation built into the Solicitors Code of Conduct and the Bar Standards Board Code of Conduct, which says that counsel can't advance any contention which they do not consider to be properly arguable. So those are the magic words, properly arguable. It's not from a case law, no judgment of a court. It is just built into the bedrock of what regulates lawyers who are registered in England. So if we formed the view that it is just not arguable at all, in other words, no matter how many tribunals you had, they would all reject it. And it self-evidently, if something is just untrue, that a factual assertion you put forward is untrue, that's even worse. But at a minimum, it is it needs to be properly arguable, is the magic word. The separate topic I mentioned was, it's in some sense a subset, is the rule that one needs to put parts of certain allegations to a witness during the course of cross-examination. That historically is described as the rule in Brown and Dunn. And Brown and Dunn is a case from around the 1860s in the House of Lords in England. But one would need to update it. It is, there are many and varied recent cases, including some in the Privy Council, which make clear that the rule in Brown and Dunn isn't complete and absolute, rather like Alex was saying. You do not need to put every part of your case to every witness, but one needs to, in some senses, identify the critical element of a case to be put to one witness in circumstances where that witness is saying completely the opposite, and it would be improper for you to leave the matter to closing argument. So it is not an absolute rule, and the underlying source is rule in Brown and Dunn. And Brown is spelled with an E, B-R-O-W-N-E, Brown, and V, Dunn, D-U-N-N. Those are that's the ultimate source of that obligation.
Thank you very much, Mr. Key. And I believe that would have answered the question. We've got two other questions which are very similar. They're asking for a reference to the books that Mr. Emerson mentioned. So I can quickly answer that. One was a book or a guidance note by the Global Arbitration Review. In short, it's called GAR. It's called The Guide to Advocacy, if I'm not mistaken. And the second book that he mentioned was the Chartered Institute of Arbitrators Singapore book or guide called The View from the Other Side, again, if I'm not mistaken. So those are the two books that Mr. Emerson mentioned. One last question to Mr. Kishan, and then we can conclude. And I believe you've already touched upon it, but just if you can save very briefly a few more remarks. It's a question by Amira, and she's asking, what advice do you have for young solicitor advocates who would like to expand their advocacy experience in arbitration, given their lack of experience, but eagerness to make a mark in the industry? So I know you've already touched upon it, but briefly, a couple of comments just to address the question.
Yeah, see, I don't know which jurisdiction you're from, but in at least speaking from an Indian point of view, what I try to do to ensure that some of the youngsters who join our firm get some advocacy experience is give them some parts of a case to argue. May not be the most critical aspect. And this happens more in domestic arbitration than in international arbitration. So where there is no time crunch and where they can take their time, choose one claim where stakes are not particularly high and give it to one of the colleagues, give it to one of my colleagues who can go ahead and argue that point, of course, with client consent. In international arbitration, it's going to be a lot more difficult because clients are usually not going to be happy with somebody arguing a point where a particular person has been engaged as a counsel. So that's one. So perhaps the learning ground would be domestic arbitration. And secondly, in India, given the volume of arbitrations, there would be matters which are not particularly well paying, and therefore they may not be cases where experienced counsel could argue it. But as a firm, we would still take up such matters with and clearly inform the clients on the first day that a younger colleague would be doing the advocacy in the matter. This helps the younger colleagues develop some experience over time. I'm sure there are similar practices in other jurisdictions as well. So that may be one way, in addition to attending the courses and reading the books that have just been discussed.
Thank you. Thank you very much, Mr. Krishnan. There's a follow-up question, but I think for Mr. Key regarding the tips, but I think he's already expressed his opinion on that, and we're slightly over time. So I really...
Well, I think all I would say is for anybody, including the questioner, look at the course that I was saying, because I cannot recommend that highly enough. I mean, I say that not merely because I teach it from time to time. A number of the people who go to it tell me many years later just how transformational it was to their advocacy. So it's called FIA, F-I-A-A. I think technically it's, I said Federation before, it's wrong, it's Foundation for International Arbitration Advocacy. If you type in FIAA into Google or a similar search engine, you will find it. I'm not saying that they have courses at the moment because of COVID issues and the like, but when the courses start running again, they will come to you or a location near you, I have no doubt. And it is the best I have ever seen or been involved in terms of advocacy training, in part because you actually get feedback directed really at you, at all the terrible things you say that you didn't realize you say, and the way you scratch your head every time you think about something, everything like that. So it's great.
Thank you very much. With that, we have come to the end of our session. And I would really like to thank all our panelists. Mr. Emerson has already left, but Mr. Key and Mr. Krishnan, thank you very much for your insightful and helpful discussion. I know that I've learned a lot from this session, and I'm sure that our audience has also benefited greatly from your advice, especially the practical steps at the end that were mentioned by all the speakers. I think they will really help junior lawyers like myself in developing our advocacy skills. I would also like to thank Paris Arbitration Week and our team here at Sultan Al-Abdulla for organizing this, for getting together everyone. Thank you very much. And finally, thanks to our audience for joining us today. We got some questions in as well, so I hope you enjoyed the session. I hope everyone has a great day and a great week ahead. And thank you very much again for joining, and we'll see you next time. Thank you.
Thank you. It's a pleasure to be involved. Thank you.
Pleasure. Thank you.